So this panel is entitled Balancing the Judicial Scales. Justitia, the blindfolded goddess of justice, holds in her hand a balance scale, scales of justice, and they need to be maintained. Unlike deficits, they don't look after themselves. So today we have two panelists and a moderator, three who are actively maintaining the Canadian scales of justice. We have Bronwyn Eyre, a former Saskatchewan Minister of Justice and Attorney General, also with deep involvement in energy and water. She's now a writer, broadcaster, and columnist of considerable note. Joanna Barron, CEO of the Canadian Constitution Foundation. Full disclosure, I'm chairman of the board of the Canadian Constitution Foundation, and pleased to say that we're partners in this conference. Joanna fights for Canadian freedom and liberty under the Constitution. She is a lawyer, writer, and commentator, as well as having her executive responsibilities with the Foundation. Two very strong agents of change in Canadian law. Moderating is Fraser MacDonald, also a lawyer, a long-serving conservative activist, involved next in corporate finance on a worldwide basis, and he's currently a principal at StrategyCorp, a public affairs consulting firm, and also a proud sponsor and partner of this conference. Fraser, take it away.
Thanks very much, Andy. So we're all out here to talk about judicial activism, and being as the good lawyers that we are, we probably need to start with some defined terms. So Joanna, why don't you start? What do we mean by the term judicial activism?
So another way to describe judicial activism is a philosophy that you could broadly classify under the aegis of progressive constitutionalism, a dominant stream of thought, certainly in the legal academy, but also in the courts, that courts need to respond almost in real time to evolution of society, modify precedents, and sort of shape the law according to what they perceive as society's needs are at the time, which of course raises the question of who decides what society's needs are and who decides when the law, can be evolved. Proponents of this view think that there is an important, and I'll steelman their position, that the courts serve a counter-majoritarian influence in this way, but they can't quite account for the fact that judges are appointed, they're not democratically elected, and so there should be serious problems just from a basic democracy and rule of law point of view with allowing judges to go completely untethered. I don't know if you have any thoughts on that, Bronwyn.
Well, I think it's advancing ideological social policy, and often under the guise of independence. I think we've seen the concept of independence become somewhat weaponized. I think it's useful to look back as a starting point to what Chief Justice Bourlasken said in the 80s about judges weighing into policy, weighing into the political realm, and comparing, even in that relatively short period of time where we're at now. I mean, he said that a judge has no freedom of speech to address political issues which have nothing to do with judicial duties. Absolute abstention from political activity is one of the guarantees of impartiality, integrity, and independence. And he asked, does it matter that many in the press think something is a desirable stance? No, there must be one standard. And I think compare that now with what we see, what we even saw with Chief Justice Wagner, in terms of his response to the convoy, a very heightened political response. I mean, he called it anarchy, hostage-taking, forced blows against the state justice, democratic institutions, and it should be denounced with force by all figures of power. And I think that it's, rightfully being questioned as the invocation of the Emergencies Act moves through from the Federal Court of Appeal and potentially, most probably, beyond to the Supreme Court, where will he have to stand on something like that? Will he have to, even potentially recuse himself? So I think in terms of judicial activism and what it is, I think it's lawfare out there. It's not just in Canada. I mean, we saw it in the last week in France, for example, where even very centrist politicians are very troubled, expressing grave concern about a judge weighing in and banning someone from running for 5 years, even though it's under appeal. So it's very timely. I think the discussion wants to, as they say, unpack.
Mm-hmm.
Yes, and so just to set the scene for everybody, I'm sure we have lawyers and non-lawyers in the room, and some who are more or less familiar with judicial philosophy or the history of the common law and the Canadian legal system. How is it supposed to work? Or what's the conservative tradition of, I mean, we often hear the term judicial restraint. So what does that mean, and what is an ideal system that conservatives would be looking for instead?
Well, I think at a very basic level, it's that people, that the players involved, if you like, should stick to their lanes. Parliamentary sovereignty is an ancient thing. It's an important thing. And I think increasingly we see an infringement into it. And I think there are some, very notable examples of what we're seeing in this country. I mean, as a starting point of perhaps where we shouldn't be going. One is the court challenges program in Canada, which, the MacDonald Laurier Institute recently reported 96% of cases are liberal causes. Funded by the federal government, $27 million since 2017, revived under the federal Liberal government, and funded 40 interveners to argue or help argue the carbon tax case on behalf of the government, a bit close to home for Saskatchewan, of course. I think that's one example. Another, in terms of what maybe it should not become, is where we see international treaties being integrated into Canadian law, Canadian jurisprudence. I mean, keep in mind that a lot of these treaties are, they're composed or they are come up with by unelected bodies. The UN Declaration on the Rights of Indigenous People, the UN Declaration on the Rights of the Child, and what we're seeing is the federal government increasingly entering into international treaties, demanding compliance from provinces in terms of adhering to them, even though for provinces they had really nothing to do with the entering into them. They will have a huge impact in some cases on social policy, on economic future. And in a way, that's becoming entrenched. So I think two examples where we're seeing in sort of common, instances out there of what it shouldn't be.
So just to add a bit of nuance to that, I agree with what Bronwyn said, but I would say I don't think a conservative approach to lawmaking and judging simply wants, deference to parliamentary supremacy. There's more to it than that. For example, the CCF, we were the first civil liberties group to challenge the invocation of the Emergencies Act, and the government's, to be honest, strongest argument, and an argument that they made over and over again at the federal court and the Federal Court of Appeal, was you need to, defer to cabinet as an apex decision maker. Now, the difference there, I don't think a conservative or libertarian view of the law necessarily means that judges need to be meek or they need to be humble. We hear a lot about judicial humility, and I think that's well conceived in many circumstances, but a strong judge can still be respectful of the separation of powers, and to me, this really comes down to the distinction, which I think we'll talk about a bit more, about positive versus negative rights. So the charter, to take the charter for example, we know in its inception, in its founding debates, it was intended as a negative rights document, going back to Magna Carta, which gave citizens rights against the government. And I have no problem with, courts acting strongly and boldly to let governments know what the boundaries are, what the spheres are that you cannot cross by. You cannot invoke the Emergencies Act without proper statutory justification and use it to infringe on liberties like freezing bank accounts. And so, traditionally, I think the courts have a lot to say about things like criminal due process and, the presumption presumption of innocence. And these are all areas where the courts are well placed to make those calls, because they are not telling governments this is how you should allocate your budget or implement social programs. So for me, that's kind of where that distinction lands.
Well, why don't we pick up on that thread? I think the Charter is negative rights. The Magna Carta fundamentally started out as a document to restrain the power of the Crown. And that's really what the whole rights-based system that we rely on, going back almost 1,000 years, is all based on limits to government power and the ability for citizens to petition to keep those rights limited. So what's happening today, and what's this new concept of positive rights? How is it different, and why is it a problem?
So 3 years after the Charter was adopted in 1982, a decision called Reference re BC Motor Vehicle Act came out of the Supreme Court in 1985. And even though we know this was the will of Pierre Elliott Trudeau and everybody else who was a drafter and signatory of the Charter, it was intended for the Charter to protect procedural due process, not substantive due process. 85, Justice Lamel does away with that and says, no, we're going to give all of these rights a quote-unquote large and liberal interpretation, and that's legitimate because the Charter is a democratically assented to document, and we are the philosopher kings who are going to decide what it means. So, the Charter itself was a negative rights document, but right from the beginning, you saw judges not being able to resist these, this new toolkit that it gave them access to, and it's gone all the way up to we're seeing not yet quite at the Supreme Court level the issue of whether the Charter protected something like a right to social housing was rejected in the early 2000s in a case called Gosselin, but there have been lots of cases springing up across the country, things like rights to social housing, governments being enjoined from clearing encampments, where courts are clearly starting to impose positive rights.
Yes, and I mean, obviously, courts, have an important role and have always had. So I think one of the reasons, though, if we're talking about what it's evolved to and what it's become, is goes back to that increasing encroachment on the parliamentary lane. And I raised the international treaties issue because, for example, former head of Amnesty International, Alex Nevy, said a few years ago, basically said, the Charter is kind of yesterday. Now we have to move on to these treaties which we want to entrench. And keep in mind that where you entrench international treaties, that moves beyond the ability of the notwithstanding clause to be invoked, and we're going to talk about that. I think that the fundamental problem that we are seeing, and certainly governments are seeing, is that they are being hamstrung and they are being demoralized by the evolution of the Charter. And we talked about, you mentioned the housing case. We saw a case in Waterloo, Ontario recently, where the court held that the region of Waterloo, even though the land was owned by Waterloo region, could not take down or work with moving down a tent encampment based on the Charter Section 7 right to life, liberty, and security of the person. And basically the judge or the court held that would hold until housing was available for every non-housed person. And so if that isn't interference into the political realm and the parliamentary realm, the social policy realm, call it what you will, I don't know what is. And that's why we have a problem. And I think governments, whether they're trying to advocate for bail reform or bear spray regulations, they feel, and we have an epidemic of bear spray cases and attacks in Saskatchewan, they feel demoralized, hamstrung, and frankly prevented in many cases from moving forward on policy, on legislation, on regulation. And so I think that obviously the balance is out of whack, and I think, that's why the discussion is important.
And so, as you said, a judge can constrain the power of a government to do something. It can't, with the stroke of a pen, create a bunch of housing. And that's the fundamental issue at stake here, is, right? Like, they can't just invent something in the real physical world, and yet they are purporting to do that, in effect.
And for a while, I think, the courts attempted to strike that balance more carefully. I mean, I cited Chief Justice Laskin in the 80s. I think that's a very sophisticated point. You know, even in Morgentaler in the 80s, the clear message very much was, now Parliament, take it away. Now it's up to you. This isn't a holding pattern. It is a holding pattern, and now it's up to you. And as you know, we've seen the absolute, you know, vacuum that's been created on that issue, you know, the abortion issue. But really, it's just interesting from the premise of that was the assumption that it would not end there, and the housing decision is very much a dictation down. Top down, saying, well, you know, until you find housing, this holds. I mean, what the government's, that's very challenging, very, very challenging. And I mean, I think, you know, even in terms of another decision we saw recently around whether citizens impacted by the convoy could sue the convoy organizers, the Ontario court in that case said, well, you know, political expression, even robust, challenging expression, is very important. But go ahead. And it's always a question in those cases of not in my backyard. I mean, the Charter's always, you know, it's very important to have freedom of speech, very important to have robust political debate, but not when it becomes awkward. And not when it becomes, I mean, as the court said, I think in that case, when there are impacts on other people, then that becomes an issue. Well, I guess that's an issue, right, with the Charter. So I think we've just seen a very slow erosion and undermining of things, and I think it's very important now that we look hard at what's happening.
Anything to add, Joanna?
Not to that, but maybe this naturally brings up how governments are responding, which I think there's been a natural sort of immune system response in the revival of the notwithstanding clause.
Yes, so do you want to start, Joanna, just with a sort of give everybody the breakdown of both what it does and what the original point of it was, including it in the Charter?
Yes, the notwithstanding clause is section 33 of the Charter, and we know that there were provincial premiers, particularly the Prairie premiers, that made it clear that they would not have agreed to sign on to the Charter without the notwithstanding clause. They saw it as a necessary safeguard against increasing judicial power, which they perceived immediately that the Charter was going to give judges a whole new scope of power and application, and it allows, you know, governments to go ahead with a law or a policy notwithstanding the application of the Charter. It only applies to certain provisions of the Charter. It has to be renewed every 5 years. It has to be publicly promulgated, so a government will be democratically accountable for it, and we've seen a vogue of invocations of the notwithstanding clause in Saskatchewan, which I'm sure Bronwyn will talk about, but also Doug Ford has warned that he wanted to use the notwithstanding clause in the case of the infamous case of reducing the number of wards in Toronto City Council. He didn't need to because it didn't turn out to be unconstitutional. Of course, Quebec has invoked the notwithstanding clause from the beginning. And the last thing that I'll say before hearing about Saskatchewan's experience with the notwithstanding clause is that my opinion, and the opinion of some of, I think, the most important scholars on the notwithstanding clause, like Dwight Newman and Jeff Sigalet, is that the notwithstanding clause is not running roughshod over rights. It's not even negating rights. It gives the legislature an opportunity to proffer a different interpretation of the content of those rights. So, for example, in Doug Ford, the city council case was about, you know, fiscal accountability. In Saskatchewan, there was an issue around non-Catholics attending Catholic schools, and that was presented as school choice. So it's the legislature saying we have a different vantage point, we have different constituencies, and we see the balance differently. It doesn't necessarily mean we're you know, overriding your rights as some of the hysterics of the notwithstanding clause would hold.
And so, Bronwyn, you're on a very short list of people in Canada who have actually invoked the notwithstanding clause. Yes.
The schools thing
so
on
you've
me.
got your notwithstanding card. We're fortunate to be able to hear sort of directly from you. And at some point, yes, political considerations come into this. And so I'd love to hear your experience in both the direct impact there, but the different considerations that went into those decisions.
Well, I mean, first of all, I think that the notwithstanding clause everywhere except Quebec is seen as some kind of unreasonable hammer. And I think, there are politics to that, and I'll maybe get to that. I mean, I think the notwithstanding clause is a very important, sophisticated tool when it comes to taking on, the topic of, what we're discussing today. Judicial activism. It is an important tool that legislatures have. And keep in mind, from a Saskatchewan perspective, that, the great architect of the notwithstanding clause was NDP Premier Alan Blakeney, who fought so very hard for its inclusion alongside Peter Lougheed in 1982. And one thing that I tried to quote a lot when we invoked it, certainly the second time, was what he said about it. And it's fascinating, because what he said in a constitutional journal in 2010 was this, it's very short. He said that the use of the notwithstanding clause does not amount to a suspension of rights. That's a false dichotomy. That with the notwithstanding clause, the state could and can, for economic or social reasons, or because other rights were found to be more important, choose to override a charter right. Sometimes rights collide, he said, but charter rights are not more important than other human rights. The charter does not create a hierarchy of rights. And that, of course, drove the NDP absolutely crazy. And the media never reported that, And I think that the point is, and just to get to the politics of it for a moment, let's again remember that Quebec invoked the notwithstanding clause. They had an automatic override on anything from 1982 to 1985. They've invoked it many times, and most recently have considered the notwithstanding clause on banning a public prayer, preventing medical grads from leaving the province of Quebec. It is a tool they use regularly, and all the power to them. I think the problem with the politics of the notwithstanding clause is when any other province other than Quebec uses it, particularly those pesky Western provinces who dare to use it. And of course it's a tool, and it's a very sophisticated, as I say, tool, and I think it's an increasingly necessary one. And so, and we've seen the conversation change a bit around, could a federal government, potentially Prime Minister Pierre Poilievre, if that ends up being the case, he has certainly suggested that that's something he wants to look at, and everyone, flips out. The point is that, again, it goes back to the debate over the point at which we've gotten ourselves.
And so that's a very good segue to one of the other big issues that's happening with judicial activism right now is criminal justice policy. We've seen, former Harper government laws around things like mandatory minimums get overturned by the courts. And I'm not a constitutional lawyer, but my take on what I've heard from Mr. Poilievre is that if he wants to implement his full crime and justice agenda, he may end up, he's not going to probably lead with that, but he may end up needing the notwithstanding clause to implement that agenda, which I personally believe would be widely supported by many Canadians, but doesn't necessarily accord with a lot of the charter jurisprudence we're seeing. So what are the threads of judicial thinking and some of the negative externalities we're seeing in the criminal justice system right now that's led to the situation we're in right now?
So we know there was a study from the University of Ottawa that of 51 mandatory minimum challenges over the last few years, 39 of them were allowed. And some have attributed this to the reasoning that judges in Canada, peculiarly in Canada, tend to adopt, which is the use of reasonable hypotheticals, where they will look at an offender, a crime, a minimum sentence, and not look at whether this is cruel and unusual for this offender, but what can that judge concoct in his or her brain that could possibly make it cruel and unusual. So for example, a 1-year minimum sentence for somebody charged with luring a child online was found to be cruel and unusual because in that case, the judge applied it to a teacher with bipolar disorder who contacted a 15-year-old student online and later had a sexual relationship with the student, and a version of these facts came up in New Brunswick. This was a case from Saskatchewan, and overturned that sentence and found that a reasonable sentence would be 30 days imprisonment served over weekends over the period of a year. So this is happening all over the place, and questions have been raised. Why are laws that have general application, like criminal laws, being judged not on the standard of the offender, not on circumstances that are likely to capture the contact, but like basically the most extreme example. They call them reasonable hypotheticals, but they're not always that reasonable. In the UK, the way that this is dealt with is that mandatory minimums, judges can impose exceptions in rare circumstances, and I think that would be a much more sensible solution. But I think that judges who continue to engage in this sort of judicial ad hocery need to be held intellectually accountable, and that's a much deeper systemic problem. I do have doubts, or I do have concerns about federal invocation of the notwithstanding clause. It would have huge implications. It would obviously apply across the country. It would change the norms about the notwithstanding clause. But I'm curious to hear what you think, Bronwyn.
Well, I mean, on mandatory minimums, it is interesting. That is where it has reared its head, I mean, in terms of the notwithstanding clause federally. I know Quebec, again, to raise Quebec, I know they've also raised concerns about mandatory minimum sentences, including for sexual minors, that's suddenly something that's been in flux, and they find, very objectionable that sometimes there aren't at least mandatory minimum sentences for, in those cases, or that's being, made somewhat more relative. And I know they've raised that issue. I mean, we'll see where that goes. I mean, I guess I would just say on the notwithstanding clause, from a federal perspective, I mean, keep in mind that what brought hundreds of thousands of people onto the streets in Israel before the attacks of October 7 were protests by people who wanted the courts to have more power than Parliament. And I think that's an interesting example of the politics of this, because I think it's fair to say that most of the people who in that case, and really what Prime Minister Netanyahu wanted was something akin to the notwithstanding clause. And that's why I raised it. I mean, what he was really looking for is that, from a federal perspective, in Israel, something akin to the notwithstanding clause, where you can kind of curb some judicial activism or interference in policy and political decisions, and that's what brought people out more than anything else, the idea. And I think it was more, people who didn't like Benjamin Netanyahu. If it were a different prime minister, and one might posit a more left-leaning one, would people be as concerned about parliamentary power as they were? And I think that's the politics of this thing, because everything is political. I mean, everything is political. And I think, including the invocation of the notwithstanding clause, depends by whom and when. And I think that's a fundamental issue, which we'll also see in the federal space, right? Mm-hmm. I mean, I have the feeling that if the federal Liberals had brought in the notwithstanding clause, and call me cynical, they did bring in the Emergencies Act, that would be A-okay.
And when we're dealing with a court system and charter jurisprudence that's based on this, to quote Joanna referring to the BC motor vehicles case, large and liberal, like they actually said the quiet part out loud here. Yeah. And so I think a lot of this, and the judges in there, I don't think they're bad people. I don't think that they're trying to do things in a way that's illiberal per se, but there is a culture permeating within the judicial system that seems to be, again, trending towards this large and liberal interpretation of rights and towards, these unreasonable hypotheticals. So where is this culture coming from, and where is it going if we don't find a way to intervene or push back?
Well, where is it coming from? I think it stems, what did Nietzsche say? There are no facts, only interpretations. I think it's very much the living tree is certainly alive and well and very living. And I think, I know there was one comment I read recently by one justice, a woman is a person with a vagina. I think that's getting there in terms of weighing into things and sort of seeing where things are coming from certainly from her perspective, not to be too binary about it. But I think that there's just been an evolution that way, and I think that it's fair to say that there's come to be a certain tendentiousness in terms of that. Of course, there are incredibly wise, fair, objective judges and justices. There's no question about that, and one can think of many cases, even from a provincial perspective, where there have been fair, very eminently reasonable judgments rendered. But I think what we're seeing, two examples. One's been with us for a long time, And it's certainly, I remember, when I was in law school, the whole idea that there are certain groups, in the country, for example, who have subjective realities which one must take into account when you render judgment on them. That's been coming, that's old news, right? So that's one. And I think the other one, I think we are increasingly seeing a kind of a watering down of innocent till proven guilty, which is worrying. I think also beyond a reasonable doubt, which is worrying. Particularly, I have to say, I think in cases of assault, sexual assault, I think that where you start to see coaching, sort of trying to prevent potentially cross-examination or preparing, over-preparing. I think those are examples of some degree of ideological tendency, whatever you feel about that. And how you combat that is the great balance. But I think that that's something we're seeing.
So I actually think we have crossed peak judicial activism a few years back in this country. I had friends that clerked at the court at the time that Justice Rosalie Abella, who's probably the high watermark of this type of judicial thinking, who famously said, the day has come for the public sector right to strike to be given constitutional benediction. And at the time, she was already seen as lacking intellectual credibility from inside the court, not obviously naming names of innocents, but it was recognized that she wrote her judgments for the Globe and Mail and not for the legal system, and she's retired and gone on to an illustrious career speaking at Harvard and things like that. Love that for her. But I actually think we've seen a bit of a retrenchment in recent years, and I'm proud to say that the Canadian Constitution Foundation has been involved in some of these cases. So the No More Pipelines Bill reference or the Impact Assessment Act reference, where the court said, no, you guys are going all up into provincial jurisdiction under the aegis of environmental assessment. Thank you. The plastics reference, where the federal government tried to ban all plastics on the vague notion that plastics were toxic, also overturned by the federal court. Of course, the Emergencies Act decision, and this winter, or this late spring, I should say, at the Runnymede Society Law and Freedom Conference, Justice Stratis gave a talk called Doctrine Ain't Dead Yet, where he followed up on one of his first talks for Runnymede in 2016, expressing great fear that everything had become completely unmoored, and saying, actually, when I go back, it's kind of like Justice Elena Kagan, when she was Dean of Harvard, said, we're all originalists now, meaning whether or not you ascribe to the philosophy of originalism to be seen as intellectually credible, you have to seriously account for the text. I would say in Canada, we're all textualists now. Like, you just can't play fast and loose the way you could in 2016. So I'm very cautiously hopeful.
Well, I mean, certainly, and those are two great examples. I mean, well, plastics and Bill C-69, obviously, I was very involved in, and that's right. I mean, there were fair decisions rendered there. Not that there wasn't quite a ride to get there. And I think that one of the great dangers, I mean, from a political perspective, that we see when we are constitutional purists, for example, and we point out that provinces have exclusive jurisdiction over natural resources, power generation, and so on, is that we often incur this idea that, why don't you just get along with the federal government? You're piling on the federal government, even on bail. I mean, when we say, listen, you've got to legislate in this space, you've got to do something, it's, easy there. I mean, provinces stop piling on. And that's become a political narrative, but it's very unfair, I mean, to the provinces, because it's only through, fighting for things such as exclusive jurisdiction over natural resources, and Alberta and Saskatchewan, were very active in that all the way to the Supreme Court, for example, on Bill C-69, that it got anywhere. And so I really, and of course your work, but I think that it's very important to continue to retain the purism and retain the facts and state them and restate them, because otherwise everything becomes much more under threat if you let those things go.
And so one of the other things we haven't really talked about, or at least directly here, is one of the other important parts of our Constitution is dividing the powers between the provinces and the federal government. And I think this current government, and I am including the current bait and switch we've had in the last few weeks, they have taken it to a new level in terms of stepping into areas of provincial jurisdiction. So, Bronwyn, as someone who's been on the other end of that, like how do the politics of that work, and how can we as Conservatives sort of stay on top of that issue and make sure that Canadians understand?
Well, I think it really goes back. I mean, the carbon tax decision was very important in that regard because, I mean, what was so important about the carbon tax decision is that it was made very, very clear by the court that this was about peace, order, and good government. It was about a national measure, and this was really a hammer. It was a trump card used by the federal government to come down you know, in the name of climate change, and that through this sort of national measure and national importance issue, namely the climate, that they could do it in this case. But the court was very, very clear that it revolved very narrowly around a price stringency. It did not give the federal government carte blanche to weigh in to provincial regulation whenever it felt like it, and that's precisely what it did. Precisely what it did. I mean, down the line, I mean, just pick one, clean electricity regulations and the rest. And the worst thing that happened from a provincial perspective was the carving out, right, of the Atlantic on the home heating issue and of the carbon, because as soon as that happened, it's not a national measure anymore. And as soon as that happened, there is no national standard. It's, again, all political. Surprise, surprise. So I think that and I find this change or this epiphany that Mr. Carney has had and the rest of them is, you know, it's hard on some level, who, you know, someone who's lived this for the past few years in terms of the fight we've had to put up to just establish the very boundaries of exclusive jurisdiction, and to now have it openly acknowledged that it was oppressive and it wasn't perhaps you know, it did have a huge effect on pricing and the rest. So it's just, but at the root of it, when people say that's decided law based on the carbon tax case, therefore they can have weighed in all these other issues in areas of provincial jurisdiction, they are not correct. And Bill C-69 proved that to a certain extent, and we were well on the way to it. We hoped being proven many more times. Of course, if it's you know, different set of circumstances, I mean, that's ultimately a good thing for the country, but it came with a hard fight.
And so we've talked about all the negative things that can happen out there when the judiciary, you know, goes off-piste, and it's both having harm in our communities, and it's changing the relationships between the federal government and the provinces. What can we, and you know, the theme of this conference is turning ideas into action. What can we, as you know, the conservative activists in the room, or just average people who care about these things, do to help influence this? Both the culture of the judiciary, keeping the media honest, making sure these narratives are actually fact-based. What have you both seen out there that is working, and what more can we do?
Well, I would say the most hopeful example of this is the Runnymede Society, which I founded with some very smart people in 2016. And now it has a nationwide presence, has a major conference, has hosted many Supreme Court judges and other judges and attorneys general like Bronwyn, and that gets incredible traction. I think, Fraser, you were mentioning you've been at some of our events in Toronto. And
I thought it was going to be 7 nerds in a room, and it was 150 smart law students, not all of whom were conservative. People were just being open-minded in a university, which not my experience 20 years ago.
Yeah, there's a hunger for rigorous, serious, structured legal debate. There is a void for it, or has been a void for it, in the law schools. And when we talk about things like, dealing with reasonable hypotheticals, how do you get rid of those? You can't, pass a law banning judges to talk about reasonable hypotheticals. You do it by bringing about intellectual accountability, by making the case over and over again that this doesn't make sense, that this is untrue to the law, that this should be essentially, you should be taboo if you do this in your reasons. Much like, I think, Rosalie Abella's, constitutional benediction line has made her a bit of a punchline, and not just in conservative circles. I mean that. So this is about shaping the deep, the water that we all swim in, and I think it's incredibly important as a grassroots movement.
Well, I'll second that on the Runnymede Society. I know I addressed the Runnymede Society at the University of Saskatchewan, and you never know when you walk into these things whether you'll have 2 people there or 200, and in that case it was about 200. And I was so heartened by that, because I was invited to talk about, again, the struggle, the great struggle, exclusive jurisdiction of the provinces vis-a-vis all these federal regulations. And what I found so heartening about that discussion was that there was just a basic interest and hunger for debate. I think that's what we're really seeing in the country. I mean, you know, it used to be that, you know, even on the evening news, you might get 10 minutes of two people going at it who were the prime players, not indirectly sort of talking about the prime players, but actually a debate. And I mean, I think that we now get sort of pablum for the people, as I've called it. I mean, it's tough out there in terms of people getting, you know, real information. So I think that we can't be afraid of debate. And we, you know, a conference such as this is important, despite, again, all the labels that one incurs, right? It's a separatism conference. You know, mega infiltrators are hiding under the stage, whatever it is. And all that we have to, you know, even to get here, sort of combat. I mean, as I understand it, I think the NDP back in Saskatchewan is you know, criticizing this very panel because it's an infringement of judicial activism, or it's questioning judicial, not activism, independence. Mm-hmm. So typical, you know, the sort of the typical thing that one has to encounter. But I think what people can do is not be afraid to continue to debate, to question, to, you know, write letters to the editor, you know, perhaps old-fashioned as that might sound, write letters to ministers, write letters to ministries. You know, there are tallies on things. People say, you know, on this issue, how many letters did we get? How many calls did we get? It's just so important to remain engaged. And I think that's what this is about, it's what the Running Mate's about, and I think that increasingly people are, I hope not giving up on debate. I think inspired to look for it wherever they can, but we have to continue to foster it.
And so what I'm hearing from you is fundamentally what I view as a conservative principle of just being intellectually honest about things and having that open dialogue. And yeah, I especially having been to those Runnymede Society events, I am hopeful that that culture will ever so slowly change. And, you know, those kids in law school now are the judges of 20 years from now. And if they are exposed to these ideas and have that intellectual accountability, it makes me think we might not get some of the decisions we're seeing today. So the last thought that I just want to make sure we all touch on here is relating to, and I remember this sort of key principle that they drill into in law school, is that the administration of justice and Canadians' confidence that the administration of justice is fair and intellectually honest is a critical part of the system. If people stop believing in the system, it will fail. And I do think that despite, I agree with Joanna, that we may have hit the high watermark of the, you know, the wokest judicial decisions out there. Why is it so important that this works? And I'm thinking particularly, I need to call her out, Beverly McLaughlin, our former Supreme Court Justice, who's been working
Chief Justice,
yeah, working for the Hong Kong Supreme Court, which is often something that retired justices do. But she has lent the good name of Canada's Supreme Court to a fundamentally illiberal regime. Why is that kind of activity, or why is the fraying of the intellectual honesty of our system so fundamentally dangerous?
Well, I mean, I think with Beverly McLaughlin, it's interesting that, you know, another judge with whom she served in Hong Kong, who also has stepped down, because she is now stepped down, as we know, British judge told the BBC very openly that Hong Kong is becoming a totalitarian state. Judges are being compromised by an impossible political environment. I think why there's, you know, cynicism, you know, about her in particular, but maybe the issue more generally. I mean, her in particular, I mean, I think the only impossible political environment for her was Stephen Harper. But in terms of what we are expecting and why it makes us cynical, I think the fact that the British judge could speak about it and contribute cautiously, but intellectually, and to what he had experienced is what we would like to see, perhaps from her, and more broadly speaking, other members of the judiciary in a similar situation. The fact that it's stumm is, I think, what makes us cynical about that situation. And as I say, I think you know, it was an unfortunate unwinding. I mean, I'm not sure anyone probably should work in any capacity beyond 75. And in her case, you know, it went a lot longer. But be that as it may, it's the silence and it's the selectiveness. And that's what makes people cynical.
Well, that was a wonderful discussion. I think I learned a lot despite being a nerd on these subjects. I think the audience took a lot out of that. So just want to thank you both for your really insightful comments. And to all of you, you know, stay on top of these issues because they do really matter.
Thank you.
Thank you so much.